when posting your questions.
Right, so it's my pleasure now to introduce our first speakers. We have Pragna Patel, who is the former director and founding member of South All Black Sisters. For 40 years, she was at the helm of South All Black Sisters and has been centrally involved in some of their most important cases and campaigns involving domestic abuse, immigration, and religious fundamentalism. For the last 7 or more years, she has led on the transnational marriage abandonment work, working closely with lawyers, academics, and others to create awareness and change on the issue in both immigration and family law. She's currently the founder and co-director of Project Resist and is a member of Feminist Dissent. Professor Sundari Anita is chair in sociological studies at the University of Sheffield. She has published widely across the 2 areas of labour exploitation and violence against women and girls. She led the first ever study on transnational marriage abandonment and worked with Pragna Patel and Sulema Jahangir to bring about the change in the definition of domestic abuse to include transnational marriage abandonment in family court procedural rules. She previously managed a women's aid refuge and has been involved in policymaking and activism to address violence against women for over 2 decades. So over to you both now.
Thank you. Thank you very much, Nicole. And it's really wonderful to see such a fantastic turnout. I will co-present this session with Anita Sundari, and we will cover the definition of transnational marriage abandonment and explore how it forms part of a continuum of domestic abuse and coercive control. We'll look at the key identifying features and patterns of abuse and abandonment as experienced both in the UK and abroad, and the barriers and the difficulties faced by survivors of abuse and transnational marriage abandonment returning to the UK. Before I start, however, I just briefly want to say that it has taken over 7 years of campaigning, lobbying, and legal action to get to a point where transnational marriage abandonment has finally been recognized properly in both in both family and immigration law, culminating in immigration rule change and guidance, which hopefully will result in access to much needed protection to a cohort of women who are extremely vulnerable. The point I really wanted to emphasize is that whilst we rightly celebrate one of the few positive developments that has occurred recently in what is otherwise a relentlessly bleak and hostile anti-immigration landscape, we should not forget that it has come about not through accident or luck, but through sheer hard work involving uncompromising lobbying and litigation over a lengthy period of time. And I don't really have time to go into it right now, maybe for another time, but just want to say that the process of bringing about this change and the various steps taken along the way is itself instructive as a classic textbook exercise or example of how to bring about change. So Anita's going to help me with the slide presentation. So Anita, can we move on to the first slide? So I'm going to talk about I'm going to sort of talk about the definition of transnational marriage abandonment. What is it? It's also known as stranded spouses. So the new Home Office guidance for immigration caseworkers, appendix victim of domestic abuse, gives the following explanation of TMA. And as you can see there, it says it's a form of domestic abuse involving controlling and coercive behavior, and refers to a practice whereby the sponsor's partner or their family member abandons or strands the partner aboard, usually without financial resources and with the aim of preventing them from returning to the UK. And it may also involve children who are either abandoned with or separated from the abandoned partner. So essentially, it is an emerging form of violence against women and girls that occurs in transnational spaces due to the overlapping processes of migration and marriage. And many frontline organizations will tell you that a significant proportion of domestic violence casework has an international dimension because of the intersection of migration, marriage, and domestic abuse. And it can also result in abandonment. Women's organizations and family and immigration lawyers are regularly contacted by desperate women abandoned abroad who need help to return to the UK to obtain legal advice and to exercise their rights. And in my experience, a significant majority are from the Indian subcontinent, that is India, Pakistan, and Bangladesh. But we have also received requests for help by women from Afghanistan, parts of the Middle East, Africa, and Latin America. So note there that the transnational marriage abandonment always occurs in the context of domestic abuse and coercive control, and forms part of the continuum of abuse and violence that women experience. And these behaviors have been clearly set out or defined in the Domestic Abuse Act 2021, which many of you will be familiar with, so I'm not going to go into definitions of domestic abuse and coercive control here, but you can see it clearly in the set out in the Domestic Abuse Act. It's also important to point out that many forms of abuse that I will outline shortly may not initially be recognized by victims because such behavior is normalized in marriage, where gender norms dictate that women occupy unequal roles that is often also internalized. And this is vital, since it will be up to advocates and caseworkers to correctly identify the forms of abuse from what victims disclose. And that's really important when we come to looking at how to support women. The extent of transnational marriage abandonment is not known, and we suspect that it will only impact a small group of women, because those group of women have actually had to have been sponsored to the UK in the first place and then abandoned abroad. Some of this work has been done in India itself, where the figures are said to be high, and Anita Sundari's research shows that. It can affect thousands of women from particularly the states of Punjab and Gujarat in those countries. But this group of women are not covered by the new changes to the immigration rules or by the guidance, because they've never been sponsored to the UK. And I will come back to that shortly. As you can see, the dynamics of transnational marriage abandonment, there's some core aspects to understand. Firstly, it is a gendered phenomenon, since it always occurs within the dynamic of patriarchal power that it creates the conditions conducive to the abuse and control of women in particular. It will therefore largely affect women, although the odd male victim may also feature. It's often a means by which perpetrators of abuse can circumvent legal protections available to women in the UK. So, for example, the domestic abuse rule and what was called the EWHC concession and is now the migrant victim domestic abuse victim concession, and other protections that are available in the family and criminal justice system. So the whole point of abandonment and the key to understanding perpetrator behavior is that for the most part, it's about preventing women from accessing their rights and protections in the UK. And that explains why perpetrators are not just interested in abandoning women in the UK, although there is a cohort of women that is affected by that too. And then the other thing I want to just mention briefly is that abandonment can also create context for further forms of violence and exploitation carried out against women due to the stigma associated with female divorce and separation and their vulnerability within natal families and in the wider society, where state support and protection is either non-existent or it's really poor. And Anita, again, will go into this in more details. Next slide, please. So as I explained earlier, transnational marriage abandonment is now recognized in law. It's recognized by the family courts, and the key text here is the Practice Direction 12J on child arrangements and contact orders in relation to domestic abuse and harm, which came into force on the 2nd of October 2017. And in it, you will see that it says, and I quote, "For the avoidance of doubt, it should be noted that domestic abuse includes, but it is not limited to, forced marriage, honor-based violence, dowry-related abuse, and transnational marriage abandonment. So it's clearly stated there that transnational marriage abandonment is to be located within the definition of domestic abuse, and it's seen as a form of abuse in itself, and reflects, and actually this recognition reflects a growing understanding of the concept of and the dynamics of coercive control in marriage and relationships. And this recognition has been really important and has had a considerable impact in how abandonment cases are handled in the family justice system. And I know that Sulema will talk more about that in her presentation. And we also see now the recognition of TMA in immigration law following the precedent-setting case of AM, which really is worth reading, and it's very simple to read and understand, but it makes clear that the issue of transnational marriage abandonment is a form of domestic abuse. And it also stated, and this is the key point of this case, that it was discriminatory for the Home Office or for the state to treat victims of abuse out of country differently to spousal visa victims of domestic abuse in country under the DVILR provisions. And Nath will go into that in more detail. And finally, we now see recognition in the VDA guidance that's available. And many of you will know that the immigration rules and have now been amended to allow for an out-of-country settlement route for victims of transnational marriage abandonment, which is a huge step forward. And of course, the now published guidance, which you can get online, provides more details on how immigration caseworkers will handle TMA cases and what they will be looking for by way of evidence. And Nicole will go into this in more detail, and I'll come back to it at the end too. Next slide, please. So from our research and the casework experience, we've identified 3 categories of abandonment. And the first category involves spouses who migrate to the UK upon marriage to join their partners in the UK, and then are subject to various forms of abuse and coercive control. And then they're either thrown out of the marital home, or they themselves leave due to the abuse to seek help in the UK, or in some cases, they return to their countries of origin. Now, we're not worried about this category of cases because they already have mechanisms for redress and protection, namely the DV rule and what was the DWHC measures, which allowed for women to leave abusive situations, claim emergency benefits, and apply to remain here indefinitely. So this category is not really a concern for us, except where women return to their countries of origin in certain circumstances, and Anita will go into that in a bit. The second category are spouses who come to the UK following marriage and then are abused and then taken back to their countries of origin, usually through coercion or deception. And again, Anita will cover how that deception works, but this is the category to which the changes in immigration rule and the guidance apply. So this is the category that we're going to be mainly concerned about in this presentation overall. But there is a third category, just for completeness, that I want to mention, simply because it does impact on thousands and thousands of women. And that category involves spouses who go abroad for the purposes of marriage, but then fail to sponsor their partners to the UK. So those partners never step foot in the UK because their spouses return to the UK, often disappear, often after having taken all their money and dowries and so on that they've been given, and they have no intention of sponsoring their partners back to the UK. So the consequence is that the foreign spouse never migrates to the UK. And that creates an incredible amount of injustice and suffering and hardship. But this is not a category that can be supported and protected in the UK because they've never stepped foot in the UK. And it is up to the Indian state or the state in other countries where this happens to do more to protect those women. And as I said earlier, abandonment frequently does involve mothers being abandoned with children or separated from their children who are in the UK. And where children are involved, there are often additional matters, such as proceedings in the family courts regarding custody and contact. And any delay on the part of women returning to the UK can be detrimental for the women and for their children for obvious reasons. And actually, for this reason, there may be a case for fast-tracking applications for re-entry into the UK. Okay, so then I want to just briefly talk a bit about some of the key features and patterns of abuse found in transnational marriage abandonment cases. And as frontline support workers and advocates will say, and many of you are, and you will have experienced this yourselves, you'll be aware of the various forms of abuse and violence that takes place in the context of marriage and relationships. In abandonment cases, we see the same recurring features and patterns of abusive behavior, except in these cases, the abuse culminates in the abandonment of the victim survivor abroad. But it's also important to note that in domestic abuse cases, isolated incidents of abuse are very rare. Histories of domestic abuse tend to reveal a pattern of repeated abuse, which often begins at an early stage in a relationship and progresses to more severe acts. So some of the key features that we've noticed in such cases, as in domestic abuse cases generally, is how victims are abused not just by their partners, but also by multiple perpetrators. In particular, the role of in-laws, and especially the mother-in-law, for instance, in perpetrating violence and abuse on daughters-in-law who have the least power within the extended family in the family structure, is an extremely well-recognized phenomenon of gender abuse within minority, particularly South Asian families. And so in this context, the dominant understanding of abuse based on intimate partner paradigm may not be wholly appropriate in respect of women who live in joint family structures or extended family networks, which isn't just about residing in the same property, but also close relationships that also involve duties and obligations to the wider extended family, irrespective of whether or not they live under the same roof. And I would go so far as to say that abandonment always relies on the collusion of spouses and family members. And in some cases, it's actually family members, such as in-laws, rather than the spouse who takes the lead on planning and executing the abandonment of their victims in their countries of origin. Another common feature is the harassment, humiliation, surveillance, surveilling of women, and the neglect that women experience in these kinds of cases. And it shows how at the heart of this behavior lies the imperative to control and coerce women. And women are subjected to rigid rules about acceptable dress codes. They're denied contact with family or the outside world and imprisoned in the home, often or in one room, or find themselves under strict surveillance with their every movement monitored. And psychological abuse is particularly perpetrated to keep victims in a constant state of fear, fear of authority, fear for their lives and that of their family, and fear for their futures as divorced and separated women. This level of oppression escalates over time and is calculated to humiliate women and erode their self-worth and self-esteem. Another feature is imprisonment in the home. This is a dominant way in which women are controlled. They're physically imprisoned in the home, and many are denied keys to the property, which means they cannot leave the home for fear of being locked out. Some are confined to one room or relegated to certain parts of the household. Associated with such extreme forms of control are experiences of enslavement and being denied access to the telephone or other means of communication with their families or relatives and friends, and more generally the outside world. And another feature is domestic servitude. Many women recount how following their marriage they're treated as, in quotes, domestic slaves or, quote, domestic servants by their husbands and in-laws. And it's actually perhaps the most common complaint that women make. In fact, a considerable number of women feel that the primary purpose of their marriage is for the husband and in-laws to acquire a domestic servant or unpaid labor for the family business, or to be a carer for the elderly or disabled members and children of the household or extended family. Women describe how their in-laws are explicit in their expectations around household chores and family rules. They're closely monitored for the purposes of seeing how they spend their time, and they're often forced to carry out domestic duties without the aid of modern appliances. They're often deprived of sleep, and they suffer from exhaustion, and suffer generally in trying to keep up with the core chores and demands of the household. And such treatment is often accompanied by other forms of abuse that involve neglect and denial of access to medical treatment and adequate food. And so the next slide shows it's very difficult. There were so many cases we could have highlighted, but these cases cited here highlight some of the features of abandonment that I've talked about. So, Pakistani national treated as a domestic slave, made to get up at 5 in the morning, control over every aspect of her life. And you can see here the collusion of the mother-in-law, or the dominant role played by the mother-in-law in the abuse that she experiences, taken to Pakistan, heavily pregnant, and actually abandoned in Pakistan in the in-laws' home. And then, and often that's because many perpetrators feel that they can get away with abuse and even murder in countries abroad when they can't in the UK. And as you can see, there are other cases too, where showing similar, experiences of coercive control, being asked to conform to very strict, rigid cultural norms around dress and so on. Facebook messages being monitored, telephones unplugged, locked in a room, and being threatened, being told that they are cleaners and they are domestic servants, and being threatened with violence if they don't conform. Next slide. Other key patterns and features of abuse found in these cases: financial abuse, including dowry-related abuse, is another recurring theme. And as you can see in this particular case, in a number of dowry-related abuse, in cases of dowry-related abuse and violence by in-laws, the fact that the spouse hasn't brought enough dowry to the marriage is often a significant factor. As many of you will know, dowry practices are common throughout the Indian subcontinent and in the UK, and typically involve money, property, goods given by the bride's family to the groom's family, usually. And often excessive dowry demands are made before, during, and even after a marriage, accompanied by threats and violence if the women and her family refuse or fail to meet the demands. It's also very common for women's dowries, that is wedding gifts, jewelry, clothes, and cash, to be retained by their in-laws, and women often tell us they don't even know what they received because they had to hand everything over, usually to their mother-in-law, as soon as they entered the marital home. So the retention of dowries and wedding gifts constitutes a form of economic or financial abuse. And not being able to retrieve their dowries on the breakdown of a marriage is particularly significant for women who are abandoned, because in a context where they have no other rights to inherit family property and assets, the giving of dowries to daughters is seen as a form of pre-mortem inheritance. So without their dowry, the chances of women being able to survive independently, even temporarily, if they are abandoned, are very slim. And other kinds of financial abuse can involve the exploitation and appropriation of women's wages, denial of food, of warm clothes, and money for personal needs. And then the next two quotes talk specifically to the issue of immigration-related abuse. And it goes without saying that women's insecure immigration status is weaponized in all these cases of abuse and abandonment. And it's very easy for perpetrators to manipulate women's lack of knowledge of their rights and to put them in positions of precariousness. Threatening women with arrest and deportation or making false declarations to immigration authorities is part and parcel of the psychological abuse to which all abused women are subjected. And in almost all cases, victims are constantly told they will be reported to the Home Office or the police and deported if they fail to fulfill expectations or transgress family rules. And it's a tactic that instills fear and prevents women from reporting abuse, especially to the police. So what you see as part of immigration-related abuse is a confiscation of documentation, including passports, biometric residence permits, by abusive husbands and paternal family members. And you victims are kept uninformed about their immigration status. This is also very common. And we've come across numerous cases where such documentation is confiscated at the airport on arrival, or without the women's knowledge during the course of their stay in the UK, or when they're abandoned abroad. And what all of these behaviors indicate is the precarious nature of these women's existence. And as you can see in relation to the second quote, where the perpetrator husband called the victim his tissue wife, I was very struck by that, because in a way it sums up these women's experiences. And what it signifies is that they are treated as disposable commodities. And they are, and hopefully now that will no longer happen, but until recently, perpetrators could abuse and dispose of them at will. So I'm not going to end here because Anita is going to talk about the circumstances of women, how women come to be abandoned and the circumstances abroad.
Okay, I hope you can hear me. Okay, so following on from what Pragna said, so Pragna outlined the forms of violence and abuse, which many of you will be familiar with. And this is where the act of abandonment itself is where we see something that's new, something that might be unfamiliar to practitioners, to those working in the field. So following a long period of abuse and abandonment, and in almost all cases, this happens in the context of ongoing abuse, though women may not recognize what's happening as abuse. We find that men and their families strategize to leave women in their home countries, so across national borders, to take advantage of the immigration control that will prevent women from coming back and thus deprive them of their rights. So I'll draw upon quotes here from research that I did in India, as well as casework that we've encountered from other countries. Hira says he often used to hit me. He'd tell me that he had much better girls to choose from, and these names are pseudonyms. After 3 years like this, we came to India for a holiday. After 2 or 3 days, he left me at my mother's place. We had return tickets, but he phoned me and said he was returning to the UK that very night. So he said that he had some work. It had come up urgently, and she should come back later. It was only later that I realized that he was waiting for my visa to expire. So she didn't know what was in her visa. He had control of her passport, her visa. He used to apply for, because of literacy, different literacy levels, he had control of all the documentation. As soon as the deadline passed, he called to say he was going to divorce me. So it's all really well planned. And similarly, in Q's case, she came to the UK on a spouse visa from Pakistan, and there were following a 2-year period of abuse from both the husband and in-laws. The 4-year period, she was abandoned in Pakistan with her child. One of her children, and the other was kept in the UK. And this is something we've seen as well, where one child might be kept back, the other abandoned, and in a couple of cases, the able-bodied child is kept back, the child with disabilities is abandoned. And she attempted to contact her husband, but he changed all his contact details. And so there's no way she could reach him. And he wrote to the British High Commission to tell them that the marriage had broken down. So this act of abandonment is very carefully strategized by perpetrators. So we often see the whole family going back to the home country, and everyone else has got return tickets, but she's got a one-way ticket. So there are several ways in which we can realize that this is a very planned act. And what Pragna was talking about tissue wife, and that concept is really important. And the research report from my research is called disposable women. And that's because these women are treated as disposable. Men can get rid of them across national borders and avoid any financial settlement upon divorce. They can avoid any criminal proceedings. If she was in the UK, she could bring that, she could leave the abusive situation and then go to the police. And this is what they avoid by abandoning her overseas. And the impact of this abandonment is massive on the women. And this impact stems from cultural norms around divorce, which create a huge amount of stigma, shame, and loss of family honor. And this is very gendered. So Pragna said that this is predominantly a gendered phenomenon, and you might see a few cases of men, but the cultural impact, the consequence, the stigma and shame of divorce is highly gendered. So there are features of abandonment which make it a very gendered form of violence. And our research in a lot of cases come from South Asia, but you'd see similar forms of stigma related to divorce in other parts of the world as well. And we've come across cases from Algeria, Sudan, Somalia, countries in the Middle East. So, for instance, married her British national husband. She was from India and she traveled to the UK on a spouse visa. And she was subjected to extreme coercive and controlling behavior. So after she gave birth to her son, her husband took them to India on a holiday, but returned to the UK without them. And she was from a very conservative and close-knit community in Gujarat. Divorce was unacceptable. And the impact of her divorce were also on her sisters, not just on her. They were considered tainted. And so it affected the marriage prospects of the sisters. For this reason, the family tried for many years to persuade her husband to change his mind, but it was only 5 years later that they decided to seek professional help. And again, W's case in Pakistan, she was thrown out by her parents and brothers because they thought, having come back after being abandoned, she had brought shame on the family and they didn't want anything to do with her. So it's very common for abandoned women to be turned out of their parental home because of the stigma around abandonment, and the social stigma around this means and loss of family homes, a huge impact in terms of destitution, homelessness. So it's these are factors that you might encounter in your in the cases in when women contact you for help. So Pragna will talk a little bit about this later on. So connected to the stigma around abandonment is the financial impact of abandonment. So because of the social status of an abandoned woman, employment becomes very difficult. So Jasminder, who was from a small village in Punjab, talked about what it meant. And there were educational opportunities. She was educated in her village. And because of that, she tried to work as a teacher in a government school. But it was impossible for her to find a job because everyone knew that she'd been abandoned. We had to leave our village because they used to say, this girl has been abandoned. In the village, if you get out and ask for a job, they ask you, are you divorced? I'd say, no, the case is ongoing. So we moved to the city. Before coming here, we decided we wouldn't tell anyone. Everyone here thinks my husband is abroad, working, and I'm living with my parents. If I told them, they'd gossip about me. And this was such a unique case. She was the only child, so the parents made the decision to sell their family ancestral land, farming land, and relocate to a city so that they could continue a life without stigma. And this was the only case where I saw this happen, where the family rallied around her. And probably because she was the only child and she was going to be their carer in their old age. Yeah, and this is what it takes to avoid that stigma. This is what it takes in small places to find employment. You have to leave, you have to upend your whole life. And in most cases, that doesn't happen. What was more common was abandoned women encountered insecurity, a very precarious existence in their family home where they managed to live there. So Jasma, for instance, said things are not easy here. And this was such a difficult interview. She was in the family home, they were all around, and then they went out, and that's when we chatted. All I can say is that I stay here. So she made a difference between this being a home and this just being a place where she's just staying there. My brother tells me all the time that I should give up my share in my father's property. My father possesses 2 houses, receives a considerable pension, but my brother says he'll look after me and my daughter and get my daughter married only if I renounce my inheritance. Where will I go? If I give this up, where will I go? And so she refused. She was a very strong woman within that house, in that context of precarity. She refused to sign those documents to give up her inheritance. And this connects to the issue of dowry. So, as far as her brother was concerned, she'd had a dowry when she got married, and that was her inheritance. And by living in the family home, he was worried that she'd claim the property as inheritance. And so she was there. Her parents were alive, and she was there in constant fear of their impending deaths, because at that point she was worried that she and her daughter would be thrown out. So huge levels of insecurity, and that's what they're living with. But despite all of these issues, the women don't just sit there and accept their fate. They try to get justice. They try again and again, and they find that this is not easy. They encounter a whole range of barriers to justice, and that's because of the legal processes in South Asia, but also in other countries where they're abandoned, where it takes a long time, it's expensive, and corruption is rife. So, DSP of police in India, who deals with abandoned women, said the legal processes are slow. It's difficult for a woman from a village to travel to a city court. There are frequent adjournments. She can't travel alone. She has to be accompanied by a family member, and the costs are high. If you compare it to the West, it's very difficult. So the legal processes are they theoretically there, but they're not accessible. And Jasminder talked about what that meant when she decided to go to the courts, when she decided to report it to the police. My husband no longer wanted me. My in-laws had turned me out of the house. I had 2 small children. What was I to do? We filed a case, and that was it. Whoever we went to took money from us as bribes. They harassed us so much. This proof doesn't work. That doesn't work. Bring documents for this and that. Nothing proceeds smoothly in our system, right? She said. They'd say they were busy, come tomorrow, afterwards. And each trip meant she had to go from her village to the bigger city nearby. And she had to arrange family members to accompany her. So the costs are massive. It went on for months. His family eventually bribed the police, and nothing came of it. So remember, the financial resources are also not even. So the husbands, ex-husbands, are in UK. They have, the pound is versus the rupee. So the financial resources they have is far more than the women. We lost all that money for nothing, and that's why often the families don't support women in this journey, because it's so difficult, expensive, and the chances of success are very low. In another case, she filed a report at the police station and got his passport confiscated. But again, he bribed the police and got it back and left the country the very next day. So he'd come back to India, and she found out about it through the grapevine and tried to secure justice, but it didn't work out. What the stigma associated with abandonment often means it often means women try for a very long time to reconcile, to work out a compromise with the husband and his family before they go and seek justice. P, for example, was abandoned in Pakistan with her children 5 years after her arrival to the UK. And it took her, she fought it took several, after 2 months, she was thrown out on the streets. She went to her parents' place, but she found she wasn't welcome there. And it was a 7-year battle for her to return to the UK with her children. She eventually obtained a visitor's visa and then came back to the UK. A was abandoned in Afghanistan, and there's a list here. I won't read the list out. But over a period of 3 years, she contacted 14 different organizations to find a way to come back. So far, before this change in VDA has come about, there was no route back for the women. So there were long delays. But even before they tried to come back to the UK and contacted services, because of the stigma attached to abandonment, women often first sought reconciliation. They sought a compromise. They often didn't believe that they'd been divorced, because for example, in India, divorce takes a very long time, and there's no both parties have to be involved in order to and agree to the divorce for it to take place. So you will see long delays of several years before women seek support to come back or before they initiate this process. And sometimes they've been seeking support for several years before they find a route. And so that's something that you will see. So last bit I want to talk about is this notion of voluntary return. And I want to take your mind back to Pragna's 3 categories that she talked about. The first, where women experience abuse and are thrown out or leave the abusive home in the UK. And that's where we want to go back to. So all the cases I've talked about so far has been about where women are deceived or coerced into going back to their home countries and abandoned there. But there are some cases where women may have left the family home in the context of abuse while they're in the UK. And you all know cases where women might go to a service and then there's the DDV concession and they may apply for that. But there are a few women who leave the family home, either flee the family home or are thrown out in the context of abuse and violence, but they have no idea that these services exist. So they might just take a flight back home. They might find a way to get the money, borrow the money, and get a flight back home. And that's classified as a voluntary return. And we would question that. Women make decisions to return to their countries of origin. So some of the women you encounter might do that in the most constraining and difficult circumstances. They're unaware of their rights in the UK. They don't know about the DDV concession. They lack support from organizations. So a couple of cases here. When an Indian national wife called the UK police for help after severe domestic abuse. So this is a big step for her. Yeah, she might have been afraid of the police. She might have been told they'll deport you, as Pragna mentioned. The police came, but they believed the counter allegation of assault by the in-laws who spoke English, and she didn't speak English, and that they didn't have translators present. And they arrested her and kept her in the cell overnight. So when she left the next morning, she was absolutely petrified. She had tried to seek support and it had led to nothing. In fact, she'd been locked up. So imagine her fear in those circumstances. In another case, C's husband lived away from home. And so he had another relationship. He married her. She came to the UK, and he said the purpose of the marriage is for you to look after the parents. I'm off. And she was subjected to domestic servitude and forced labor. But her in-laws wanted grandchildren, and she refused to have sexual relations with her husband because she said he's somewhere else. He's not involved with me. But her mother-in-law spiked her drink to enable her husband to rape her because she wanted the grandchild. And the next day, she had the drink, fell asleep. She woke up the next day and felt pain all over her body and her stomach. She found bite marks on her breasts, and she realized she'd been raped. And that's the circumstances in which, as she went to work that day, and she spoke to a friend of hers, she didn't have a mobile, and through that called an acquaintance who was in the UK, borrowed money, and left UK. So she had hidden her passport under her mattress, and so that day when she went to work, she took her passport with her, knowing that she wanted to leave. So these are the circumstances under which, in a state of fear and panic, women may leave. We don't think it should be considered voluntary. So there'll be some cases you'll encounter like this, and that's the argument that you need to make. So I left UK in desperation. She says, I didn't know I could apply for indefinite leave to remain as a victim of domestic abuse. So hardly voluntary circumstances. And another
Anita,
aspect,
can I just let you know 1 minute to the end?
So yeah, I've got conclusion in next slide. So another thing you might encounter is abandonment after the woman has obtained independent leave to remain. So in this case, she had independent leave to remain, and according to the terms of that, you can't be away from the country for 2 years. Her husband coerced her and her son, who had a speech and impairment, to go to Afghanistan and stay there beyond the 2-year period. She didn't know there was this rule. And so, despite her ILR status, she had been effectively abandoned. So you might see, these are cases that you might see that don't follow the norm, but they're still, we'd argue, transnational marriage abandonment. And Nicole, you'll be pleased to know, I'm about to conclude. So to wrap up what we've said, TMA is a form of domestic abuse in and of itself because it involves coercive and controlling behavior. And the intention of this behavior is to deprive the woman of the right to, of various rights and entitlements that she might have if she was in the UK. It's commonly accompanied by other forms of domestic violence and abuse, but even in its absence, it's possible, you should be able to argue that in itself, it's a form of abuse. And this is important because women may not see what's happening to them as abuse, and particularly some forms of abuse, like economic abuse, servitude, verbal abuse, coercive control. Women may not articulate that as abuse. So it's for you to search for that in their statements, to ask questions. The impact of TMA is wide-ranging: stigma, destitution, financial insecurity, and combined with the lack of routes to return so far and the justice systems in home countries, it might mean that there are very long delays of several years before women apply to return to the UK. And the last point, what seems to be a voluntary return may not be voluntary. So it's really important to probe the circumstances in which this happens. And to end, I'll hand you back to Nicole. There's some references here, a few articles that you might read, the research report, and there's a YouTube, a brief program on this, which you might find useful. Thank you for listening, and I'll stop sharing.
Thank you so much. Thank you, Anita. Right, we'll move on now to our next speaker, who is Sulema Jahangir, a family law solicitor and partner at the law firm Dawson Cornwell. Sulema works on all aspects of domestic and international family law, including child abduction, child custody, and she regularly acts for the victims of forced marriages, abandoned spouses, and so-called honour-based violence. She is a dual qualified solicitor in both England and Wales and Pakistan, and frequently works on cross-border cases with Pakistan. Sulema is an expert in Pakistani family law and regularly provides expert reports to courts across jurisdictions. So Sulema, over to you.
Thank you, Nicole, and thank you for inviting me on this to speak on this very important topic, and something which I, Prabna, and Anita have worked together on for many, many years, and actually seen some progress on the work we did. You don't see progress in a lot of work, but in this area we have, so I'm very proud of that. I want to start by saying that, you know, what we have discovered is that in courts that there are new forms of violence against women that we constantly see emerging. And abandoned spouses is kind of a new form of violence. It's been around for a while, but it is something that, for example, legislation does not really cater to. So it's kind of fallen off the map. Maybe it's because the victims of such violence are usually the most vulnerable people. I mean, I've done much over, let's say, 100 cases of abandoned spouses, and I have yet to come across a woman who has a reasonable amount of wealth or a career or, an independent means who has been abandoned like this. So I think where the victims are so disposable for our policymakers to an extent, as well as others, you see that they kind of get off, there's a space where people don't really bother about them. And sadly, that is where we are. So what I'm happy about, and that this is one of the rare instances where one feels proud as a lawyer, is that you see that courts have had to fashion remedies for these most vulnerable people. And usually this is in the guise of child protection. So we see two kinds of remedies from the court. One is wardship and inherent jurisdiction of the High Court, where the High Court is able to fashion sort of any kinds of remedy, because under its inherent jurisdiction, it has a lot of flexibility. And on the other hand, we've just recently seen in actually one of our cases where which actually Nat did on the immigration side, where we got the EWHC rule, which has now been expanded to cover women who are abandoned in only in some cases where they are on a spouse visa, etc. So I'm going to start sharing my screen. Sorry, quickly, but basically, yes. So you can see the screen now. So I've started by saying, by setting out a quote from one of our cases where the judge kind of tries to summarize the unfairness of these cases In this case, the mother had been stranded, the child had severe learning difficulties. No one bothered, sometimes these cases go to social services couldn't find out where the mother was, said, well, the child is fine with the father, and ignored the whole case. And that made the judge really angry. And you can see this quote from the judge. I talk about Southall Black Sisters and their work on this, which Anita has done along with Pragna, and that is one of the most in-depth reports, which actually looks at abandoned women in India and sort of tries to categorize them, which I think has been really helpful for everyone.
Selena, can I just jump in and say, would you like us to show the slides? Because
yes,
yours is...
Am I sharing the screen?
You're sharing, but I think you're further ahead in your slide deck. We're happy to do that for you if you'd like.
Is it not the first page?
No, I think we're on I've got the last page.
Is this better now or no?
Not for me. Zoe?
Okay, if you can share them, that'd be great. Thank you.
Okay, we'll do that. If you stop screen sharing, we'll start.
Okay, sorry about that. I don't know why it is. Okay, I will stop this screen share. Sorry about this.
It's all right. You don't need to stop. I think I've taken over.
Okay, great. Yes, so so I put in a quote from one of my cases about this. So the two areas that we have is wardship. If you can go on the second slide, please. Is wardship and the inherent jurisdiction of the High Court. I put in the legislation here, which the courts are supposed to consider, and as I said, it gives the High Court a lot of flexibility. The difference is that, as Pragna and Anita said, that these are cases where women have children, and it is only here that the courts are able to fashion a remedy for them to be able to sort of get their rights back. And not in every case do we have that, and I'll explain which cases are different from others. But where there are children who are either abandoned abroad or have been separated from their parents, those cases can be started in the High Court, and there will be an application for wardship. Can you go on the second one? So so this is how the court started crafting remedies. The first case which gave guidance on this was a case of Mrs. Justice Hogg, which was the VS case. And luckily for this case, that after this, all the courts were bound to follow a precedent. And Mrs. Justice Hogg really helped a lot, many hundreds of women after setting this guidance, because initially when these cases came up, judges didn't know what to do and how they should go about it. But she said, well, look, these women's Article 6 and Article 8 rights are being being breached. They have a right to a fair trial under Article 6. They have a right to a family life under Article 8. And if they're being separated from their children, well, those rights are in breach, and therefore we have to do something about it. And so she gave very helpful guidance where the court now has to consider whether a CAS officer, which is a family court officer, which looks into how the child is, what the child's wishes and feelings are, whether they should be appointed. There's also a request made to the Home Office to find out about the mum's immigration status, which is also very helpful, because in at least a quarter of the cases that I've acted in, once the husband abandons the wife abroad, he usually then sends an email, and usually from the plane, if you believe it or not, saying that, well, can you cancel her spouse visa because her marriage is broken down? So all of that comes before the court, so that later when he says, well, no, I never abandoned her, she wanted to stay back of her own volition, and almost in 95% of cases, they say that. Well, you point to that email from the Home Office and say, well, why did you write an email to the Home Office? So, these are things that the court helps. And given that it's in a high court, it's the cases happen really fast. The judges have a lot more power. The only place where you then encounter problems are, again, with immigration law. And this is a tension that has been between two arms of the let's say, the legal system in England. One is that the courts courts are adamant that the mother needs to return. She needs to be united with her children, and even if she needs to give evidence in person about where this child has to live, etc. And on the other hand, what happens is that the Home Office continually denies the visa, saying, well, you do not have a sponsorship, you do not have any money, your husband has cancelled your spouse visa, so why would we grant you a visa? So you see these two tensions, and you can see this. The court has has started making new forms of recitals, saying, please, we make a plea to the minister that this is really important, that these women are not denied visas. But yet we continue to see that this happens until recently, where there has been some progress with the new case in immigration law. So if we could have the next slide, please. So here we see the court saying, well, to separate a mother and child is emotionally harmful. So there are so many different declarations and recitals made by the High Court in various reported cases, saying that they have been deeply upset that the mother has made several applications to the Home Office, but they have not been allowed a visa. In many of my cases, I've seen that eventually the Home Office does relent and they have been able to obtain a visa to come back. But in some cases, this has not happened. For example, in this case in NNA and Nakhtar and Ayub, the Home Office said, no, sorry, we will not be able to grant her a visa because of various reasons. She didn't have enough money and she didn't have a sponsorship, etc., etc. And in that case, the mother was permanently separated from her 6 children. So, those are the cases which we try and avoid, and these cases will still continue to happen even with the DDVC rule, because those rules are often for people who have a spouse visa. Some of these women do not have spouse visas; they've come on through other routes which are cheaper, or where the restrictions are a bit more relaxed. So then they fall into, again, this problem with trying to get a visa from the Home Office. If we can go on to the next slide, please. Again, I've put in another quote from one of the reported cases where the judge explains that this is a wholesale breach of their right under Article 8 of the Human Rights Convention. And then another case from Mr. Justice Holman, where initially the judge had given up on another case where the woman was not granted a visa despite several applications. The judge said, well, there's nothing I can do. This case has to be discharged. But in a further case after that, what happened is that in that case, the judge felt more sympathetic because the victim here said, well, I've appealed the visa refusal, and she actually did win the appeal eventually. And her position was also that if she is not able to return to the UK, she wanted the child returned to her in Pakistan. And so the judge said, well, in that case, we cannot discharge the wardship and we must continue with the case. If we can go on. Second slide, please. The issue is in a lot of these family cases is jurisdiction. Jurisdiction is often the trickiest part. And a lot of the cases that come to me, the first threshold I look at is their jurisdiction in the court. For example, in a lot of these cases, as I said, I've never come across a woman who is very fluent in English, had a job in England, etc., and then was abandoned. A lot of these women are very vulnerable. Many of them do not read or speak English, so they really do not know what to do. In a majority of them, they try and approach family members first to try and see if something can be done and they can be taken back to England or their passports can be returned to them, and they wait. And waiting is the difficult bit, because the longer you wait, the less the court is likely to assume jurisdiction in your case. And in some of these cases, what's happened is that I've been unable to help them because the court would not assume jurisdiction. Because if the children are abandoned with their mother, and they've taken too long, then the court will say, well, we don't have jurisdiction. This child is no longer living here for so many years. it is the Pakistani or the Indian or whichever court that you have to apply to for relief. And sadly, those cases, it becomes difficult to help them. And there are many, many of them. In some of these cases, we have tried our best. So there are some cases that fall on the fringes. For example, in one case, the mother had waited 4 years, but in that case, one of the siblings was with her, was abandoned with her in Pakistan, and the other sibling was in England. So it was a split siblings case, and the judge did assume jurisdiction. In another case where we had a 3-year delay, the mother and the children were abandoned in Saudi Arabia, where they did not have any legal status. So they were basically out, the children were out of school, they were in sort of hiding, and the court felt that they had not integrated into that jurisdiction simply because of their situation there as illegal immigrants, and the court did assume jurisdiction. Then there is a very, very famous case of AP, which was in the Supreme Court. In that case, we basically appealed because the Court of Appeal said a child who had never set foot in this country, you cannot make a ward of the court because that child was born while the mother was stranded abroad. The Supreme Court unanimously allowed the appeal, which was quite a big victory, and said that even if that child was born abroad and was born while the mother was forcibly stranded there, the English court would have jurisdiction over that child on the basis of that child's nationality and because of the extreme circumstances of that case. So since then, actually, we have used this case, believe it or not, in at least 4 or 5 cases, just in our law firm, because of the sort of unique circumstances that you come across every day with different cases. Could we have the next slide, please? Okay, so now is the case where there is no jurisdiction. And, these as explained before, well, what Anita had said that, there are stranded women with no children who come in, I think, the first category. And the court doesn't have any jurisdiction, obviously, because it only has wardship and inherent jurisdiction where children are concerned. And then there are stranded women and children who have never been to England. And often I get calls from women who say, well, someone came and, it was a British national, he promised to take me, but never did. And I've never been to England. And, it's sad, but they do not have a recourse, at least where the wardship or inherent jurisdiction is concerned. In terms of other recourse, it becomes really complicated. And the complication is that if, for example, the women are looking for financial remedy proceedings or divorce or maintenance, it becomes very difficult for them to get public funding or legal aid. And they are often unable to afford legal fees. And the reason being that public funding is usually given when you have evidence of domestic abuse. And these women do not have the correct evidence of domestic abuse, because if you look at the specifications for that, it is very strict and it applies to domestic abuse mainly within this country. And if it's abroad, it has to be sort of a conviction from the court, etc., which hardly anyone does have. So they're unable to get public funding for financial remedy proceedings, and so they basically are in a bad place. Now, at least between India, Pakistan, and the UK, there is a treaty where you are able to get a maintenance order from your own court, and you are able to sort of enforce that through a remo process, which is reciprocal enforcement of maintenance orders. But that treaty has really fallen into disuse, and I don't know of anyone, and I've tried to find cases in England and in Pakistan where people have used this treaty to enforce maintenance orders from abroad. And I find that this is, again, another area which policymakers have ignored. So, for example, within the EU, within developed countries, you have treaties where maintenance orders are reciprocal. There is enforcement, and some of it goes very smoothly. But where the poorest people are concerned, they are really left with no remedies. The other area where there is no jurisdiction is where the women have been stranded for a long time. which I've already explained, and sadly, they've left it too long. And if their children are in England, they can try and obtain contact with them. But again, they need to provide evidence of domestic abuse, the requirements of which are quite strict. Next slide. So just to conclude, I think it is fair to say that it is easier for mothers to resume care of the children where their stranding is not long-standing. And in such cases, it is the High Court has fortunately fashioned, there is a lot of judicial precedents starting from 2010 from the case of VS. We now have, I don't know, many reported cases catering to all sorts of circumstances. The court is also very good at where the children are alienated. The court is very good at looking at maneuvering this and also using the expertise of a skilled CAFCAS officer. So, for example, in some of my cases, in actually quite a few of my cases where there's been a lot of alienation, the cases have really dragged on for years where the court has not given up and said, well, we will have to try and get these children to have a relationship with their mother. The other area is where the other conclusion is that really where the children are abandoned with their mother in for example Pakistan or India, and then once the mother returns with the children, what does happen sometimes, which causes a problem, is that when the mother returns, the High Court says, well, I'm going to discharge this case now because the mother is returned and the High Court does not need to keep this case on. It can go to the family court. But what happens then is that there is no fact finding, and there is no finding by the court saying that this woman was indeed abandoned or stranded. And so again, the problem that she has is to prove domestic abuse, and she's unable to get public funding for the family court hearing. So that again is a problem that we see when a stranded spouse returns to England. Next slide, please. The other problem is financial relief. When these women return, they are usually, they are desperate, they're destitute. Thank you to, women's charities who help them. But other than that, they have sometimes no recourse to public funding. And the court can order maintenance under its, the High Court can, under its wardship and inherent jurisdiction. But, and it does on occasion, but often it does not. And where it does, I feel women are much better off. The financial relief proceedings for divorce, etc., take a very long time. And again, we have the problem of public funding, getting them legal aid. Slide, please. So I have some, next slide, please.
Just to let you know, Salema, that's pretty much time. If you could wrap it up, please.
Okay. Well, I've got some case studies here, 3 case studies. The first one is where there is not a long stranding. The woman starts family, she's got children, and I've just explained what happens in that case. Usually it's a happy outcome. She is returned, she is reunited with her children, etc. The second one, if we can move on, the next slide, please. Is where she takes a long time to start proceeding. And that is where the issue of jurisdiction comes up. And the court has to see whether it's been too long and whether the child has settled into integrated in the other jurisdiction or not, and then makes a decision. And the third slide, please, the last one. Well, this is where this is what happens is where there's no where there are no children. So no proceedings can be taken. The only option for this stranded spouse is that she has to try and obtain financial relief. And again, we get into problems of getting legal aid and the difficulty in that. So really that sums up what the legal position is for abandoned women and how the courts have dealt with it so far. Thank you.
Thank you so much, Salema. This room is full of lots of immigration advisors, so we're really fascinated to hear the family law perspective. Thank you very much. Right, our final speaker before a short break is Nat Gbikpi. Nat is an immigration solicitor at Lee Day Solicitors and also a visiting fellow in practice at the London School of Economics. She was the instructed solicitor in the case of AM, which led to the immigration rules being amended to allow victims of transnational marriage abandonment to re-enter the UK. Over to you, Nat.
Thank you. I'll try and share my screen. Can you all see my screen?
Yes.
Great. So I'm just going to talk a little bit about the background to the case of AM, which, as Nicole said, brought to the changes in the rules. I'm not going to spend an enormous amount of it on it because obviously we're more interested in what the rules are now and what we can do now to protect and to assist the victims of transnational marriage abandonment. But I think it's important to look a little bit about at the background for two reasons. One is just to see the sheer amount of work that led to the changes, which Pragna also briefly mentioned, but also because it shows the way in which abusers were actually using a loophole in the law to make sure that their victims weren't protected. And really the phenomenon of transnational marriage abandonment arose partly as a result of that loophole. And hopefully with the changes now, the phenomenon will slow down at least a little bit, because women or victims are now able to come back. And so there is less of an incentive, so to speak, for them to be abandoned. So just to talk a little bit about what protections victims of domestic abuse had so far. And those protections really came as a result of a lot of campaigning, including my Household Black Sisters, that Pragna was a director of for many years. And I'm sure a lot of people in the call are very familiar with those. So I'm not going to talk too much about them. But just to summarize, victims of domestic abuse who are in the UK and who are in the UK on spouse visas, if their relationship breaks down as a result of domestic abuse, they are able to apply for to get access to benefits, which allow them to leave the abusive household. And then they can also apply for indefinite leave, which means that they have the right to be in the UK permanently and independently of their spouse. And the reason the campaigners fought for those changes and for those rules were to make sure that victims of domestic abuse didn't have to face the horrible decision of either staying in an abusive relationship or facing the prospect of being removed back to their home country, because the only reason they had a visa and were allowed to be in the UK was the fact that they were in a relationship. So if the relationship broke down, they were facing the prospect of removal. So really those rules exist to make sure that victims of abuse do not face the choice between staying in an abusive relationship or being removed. Now the problem, the loophole in those rules was that it specifically said that victims of domestic abuse had to be in the UK to make an application. And what that meant is that victims of transnational marriage abandonment in that second category that Pragna referred to, so victims who were in the UK on spouse visas and then got abandoned abroad, they couldn't benefit from those protections. And they couldn't benefit from the rules because they were outside of the UK and the rules said you have to be in the UK. Now, why was it an issue that people outside of the UK couldn't, that there wasn't a rule to allow them to come back? Well, I think the presentations we've heard from Pragna and Anita and Sulema made the point quite obvious that a lot of people just weren't able to come back. And really in practice, we saw that a lot. The clients that I've seen and that other people in other panelists have assisted, many times when they came to us, they had already tried to get support, but just weren't able to. So a lot of victims would have approached the British Embassy, for example, and were told, "Oh, we cannot help you because you're not a British citizen." A lot would also have approached lawyers, and lawyers would tell them that they couldn't help because there wasn't a visa for them to apply for. And really, it's just there were just a handful of us that were assisting, and it's not because we're better than others, but just because we had developed that quite niche expertise. But the fact that there was no route meant that a lot of people were not given the support needed, or weren't even seeking it because they didn't think there was any way to come back. The few victims that did manage to get support, the applications that we would need to make because there was no route, often it was an application outside of the rules. And what that means, without being too technical, is that we were relying on caseworkers' discretion. So Home Office caseworker that were looking at the application would have to use their discretion as to whether or not they would grant a visa, but also what visa they were granting, what conditions were on the visas. And so what it meant is that we really got very mixed results. Some people were refused altogether, or other people were granted a visa, but it would be valid for a month or 3 months or 6 months. Some people were granted access to benefits and others weren't. So it was really impossible to know what a person would get what visa they would get, if any visa at all. The other issue we were getting was that so, for example, we sometimes had clients who were parents of British children, and so the application they were making to come back was an application on the basis of being a parent. What that meant once they were in the UK was that they couldn't then apply for indefinite leave on the basis of being a victim of domestic abuse. That's because one of the rules, which Nicole will be talking about, is that your last grant or your last immigration status was as a spouse. So people who then got immigration status as a parent no longer met the rules to be granted indefinite leave once in the UK. So you continue to have to be penalized, basically, for having been abandoned abroad. And just two other difficulties that we were experiencing without a route. One was that it was really difficult to get a fee waiver. So when you make an application for a visa, oftentimes it comes with a fee, and it was really difficult to get that fee waived. And obviously, a lot of victims of transnational marriage abandonment are destitute and don't really have access to the funding needed to pay for the visa fee. And similarly, they often don't have access to funding to pay for a lawyer, but they were equally struggling to get legal aid, again because there was no route and no visa. Now that issue has not completely been resolved, as Nicole will talk about, but we're hoping that it will be resolved soon. But what all of that meant effectively was that as long as the abuser managed to abandon their victim abroad, they knew that they would really struggle to come back to the UK and to have access to their rights and justice. And so really what that was, as I said before, it was a loophole in the rules that was exploited by the abusers. And they knew if I abandon the victim or birth, they're not going to be able to access justice and to access the protections that the Home Office have for them. So what we did, there were a lot of discussions with the Home Office by a lot of the panelists on the call today, but unfortunately, the Home Office either ignored some of the conversations or delayed making any changes. And so eventually we decided to try through the litigation route. So it had this client who was called AM, well, AM are her initials, and her case was really a textbook case of transnational marriage abandonment. She came to the UK as a spouse of a British citizen, and then was subject to abuse for years, which she didn't disclose to anyone until the abuse became so violent that she ended up in hospital, and medical professionals asked whether there was abuse, which she eventually disclosed. Several professionals then became involved, including the police, a domestic abuse organization, the medical professionals, and so on. Her husband then told her they would go back to the home country for a holiday. Strikingly, AM at that point already feared that she would get abandoned, and she raised the alarm. So she told social workers that she was scared she would be abandoned. But no one really listened to her. I think that also talks to the fact that the phenomenon of transnational marriage abandonment really needs to be known by more people and by more professionals, so that people are take steps to ensure that people don't get abandoned. Anyway, her husband threatened her, saying that if she didn't travel, he would harm her family. So she agreed, if we can use that word, to travel with him and their 2-year-old daughter. They got back to the home country. She went to stay with her own parents and her daughter, and the husband was staying with his family. And he would come every day to pick up the daughter and spend the afternoon with her, and then return her home at the end of the day. But one day he didn't come back, and he instead came back to the UK with their 2-year-old daughter. AM then tried to get support. She made an application for a visa to come back to the UK, because her husband had taken her documents away from her. That's when she discovered that she no longer had a visa, and her application was refused. She also contacted the British Embassy, was told she couldn't get help. Eventually managed to be in contact with Tasma Black Sisters, and Sulema, I believe, was her family lawyer, and then was in contact with myself. And what we did was we submitted an application for a visa, and we said she should be granted indefinite leave on the basis that if she had been in the UK, that is what she would have had. And the only reason she couldn't get indefinite leave was because the abuse took the form of abandonment. And we said, but really that wasn't a reason not to have the same rights as victims of domestic abuse in the UK. What the Home Office did was granting her a visa outside of the rules, and it was valid I now can't remember whether it was 3 months or 6 months, but definitely not more than 6 months. And importantly, it was without access to benefits. So AM came back on this visa, did not have access to benefits, so she was supported by a charity, South for Black Sisters. By that point, there were family law proceedings, and the family court had said the daughter had to be returned to AM, but AM couldn't actually get her daughter back for a while, and that's because she didn't have access to benefits, and therefore the social workers didn't think that she had suitable accommodation for her daughter. So really, even when victims were able to come back, because of the visas they were granted and the conditions of those visas, they were still struggling with the relocation, and in this case with getting the child back, even though a family court had said that it was right for the daughter to be back with AM. And the only way she got access to her daughter eventually was because the charity managed to get her an accommodation that was suitable enough for her and the daughter. Anyway, we then brought proceedings to the court and said AM had to be granted indefinite leave. And again, we made the same arguments that the only reason she didn't have that visa was because she had been abandoned abroad, but that was a form of domestic abuse, and so she needed to have the same protection as victims of domestic abuse who hadn't been abandoned. At that point, the Home Office granted AM indefinite leave, and then tried to say we don't need to go to court because her case has been resolved. We then argued that it was important for the court to look at the case of AM, but not only the case of AM, but all of the the more wider issue of victims of transnational marriage abandonment. And thankfully, the judge agreed with us that it was important to look at the phenomenon because a lot of other victims were affected. And what the judge found was that the differential treatment of victims of transnational marriage abandonment compared to victims of domestic abuse in the UK was discriminatory, which was quite obvious in the sense that they didn't get the same protections. But for that discrimination to be unlawful, we also needed to show that the reason for the discrimination wasn't justified or wasn't proportionate. And interestingly, really what the court found was that there was no reason at all, and it was rather than that the Home Office didn't really think about the cases of victims of transnational marriage abandonment. So they found that it was unlawfully discriminatory, and we won the case. And the Home Office decided not to appeal against it, meaning they then had to implement the changes, which they have finally done a bit over a year after the decision in AM was published. And Nicole will be talking about that in after the break.
Brilliant. Thank you so much, Nat. Right, we're going to take a super short comfort break. So let's just take 3 minutes and we'll get started on the next presentation about the immigration rules themselves. So we'll see you back in 3 minutes. Right, can I just check that you can see the slides all right?
Yes, we can.
Fantastic. Right, welcome back everyone. So I introduced myself earlier, but for the benefit of anyone joining now, my name is Nicole Massery. I'm an immigration solicitor and the Senior Legal Officer at Rights of Women. As well as having experience assisting victims of transnational marriage abandonment in our advice services, Rights of Women has been working alongside others here today to help bring about the changes that I'm about to explain. So for the next 20 minutes or so, I'm going to talk about the new immigration rules on transnational marriage abandonment. Now, government has created a re-entry route for victims of transnational marriage abandonment. And it's done this through the introduction of immigration rules, which came into force on the 31st of January last month. The section of the immigration rules relating to victims of abandonment can be found in Appendix Victim of Domestic Abuse, and the link to find those immigration rules online is up there on the slide. These new immigration rules mean that victims of domestic abuse who are abandoned overseas can apply for a visa that is independent from the perpetrator of their abuse to re-enter the UK. In the language of immigration law, we call this an entry clearance route. And that means that victims of abandonment who are eligible under this route will need to make their immigration application from overseas and wait for a decision giving them permission before they can enter. The abandonment application is for settlement. So that means if victims are successful in their application, they are granted indefinite leave immediately. And as you'll all know, indefinite leave is a permanent immigration status, and it's the most secure status that a migrant can have short of being a British citizen. Unfortunately, it is not possible to apply to the EWHC if you're outside the UK. There is only one application that victims of transnational marriage abandonment can make from outside the UK, and it's this application for settlement that I am talking about. There are two types of guidance on this route that you can find on gov.uk. The first is guidance that's published on the government website intended to be read by applicants. So we call this applicant-facing guidance. The second is the policy guidance that the Home Office writes for its own caseworkers who are deciding applications. And that contains really important explanations of how the rules work and how to determine applications. Immigration advisors in the room will know that they should always read the immigration rules and the accompanying caseworker guidance carefully before making any applications. The caseworker guidance is particularly important for this re-entry route for victims of abandonment because it confirms quite a significant departure from the usual approach to deciding applications. So usually, when a caseworker is deciding whether a requirement of a rule is met based on information before them, the usual principle is that they need to be satisfied that it's more likely than not that the requirement is met. So lawyers call that the balance of probabilities. Decision makers never have to be 100% sure. They only have to think that it's more likely than not that the domestic abuse has occurred. The caseworker guidance changes this for the abandonment route. For an application that's made from outside the UK under this route, the standard of proof is a reasonable degree of likelihood. So that is lower than the balance of probabilities. The guidance has also got lots of other useful content like the quote up on the slide. Victims abandoned overseas are more likely to be in situations of vulnerability and face additional barriers to applying as compared to those in the UK who may be able to access support service. So it's really important recognition of those additional barriers for women abandoned overseas. Let's look at the core eligibility requirements to make an indefinite leave application from overseas. The route is only for victims of domestic abuse who have previously been in the UK with a specific partner visa. So the same criteria applies on the abandoned route as it does for the route inside the UK for victims of domestic abuse to apply for indefinite leave. So the same as that set DV route. So that is that the applicant already has or last had, their last visa was as a partner of a person who is British, settled, or a refugee. So the partner visa must have been granted under the family member rules or the refugee family reunion rules. Or some lesser known categories, the last partner visa must have been granted under the family member rules of Appendix FM, but as the partner of an EU citizen with pre-settled status. There's also quite a niche category, much less common, where the last visa was granted under something called Appendix Armed Forces as the partner of a member of UK Armed Forces, and there's some additional criteria for that group. Now, in some cases, the applicant will still have a partner visa that is valid when they apply, but more likely their partner visa will have expired, and that's fine as long as the last visa that they had in the UK was in one of these permitted routes. So this acts as a gateway to the route. If you don't have, if your last visa wasn't in one of these categories, you don't fall under the scope of this route. After identifying that an individual is eligible because their previous visa was in one of those permitted categories, the remainder of the eligibility requirements are about the domestic abuse. Again, here, the main requirement is the same as for the in-country route for victims to apply for indefinite leave. So the applicant has to show that their relationship with their partner has broken down permanently because of domestic abuse. And the applicant will have to provide whatever evidence they have to prove the domestic abuse. To all the VOG professionals who are in the room, where you're involved in a case, your assessment is an important piece of evidence that has to be submitted by way of a supporting letter with the application to really assist the applicant. So you'll be familiar with doing those for in-country applications, and hopefully where you're involved in a case will be able to do those for out-of-country applications. Where VOG professionals in the UK are not involved and other evidence cannot be obtained by the applicant, it is notable that the caseworker guidance addresses this and recognises that applicants may not be able to obtain and produce evidence in the same way as in-country applicants. And it also confirms that it's possible to rely only on the applicant's account as evidence if it is reasonably detailed, consistent, and plausible. The third of the core requirements for eligibility is essentially if you're applying from outside the UK, you need to show that you've been abandoned there. So caseworker guidance again has some helpful content that advisors should read, including a list of indicative features of transnational marriage abandonment. The guidance also importantly recognises that abandonment itself is a form of domestic abuse. Therefore, if an applicant shows that they've been abandoned, that is enough to prove both this requirement and the previous requirement that the relationship has broken down because of domestic abuse. Let's now look at the application process. So when applying, a specific application form needs to be completed, and I've given you the link to it on the slide. The first question that you'll see is it asks you which visa you're applying for, and you need to select the return to the UK option. Where a woman is applying with children, the children can't just be added in a field on her application form. The children will have to complete their own separate application forms. The usual fee for indefinite leave applications applies to this route, which is currently £2,885 per person. But like the in-country route that we're familiar with, there is a fee waiver option too for this out-of-country route. And I'd expect that most applicants will need to apply for a fee waiver. The fee waiver we're familiar with is officially one of destitution, which is defined in the guidance as meaning the applicant can't meet their own essential living needs. In practice, I think it's more likely to be applied as an affordability test, but we're really interested in you reporting any issues that you see with the fee waiver in practice. Applicants will need to provide information and evidence about their income and outgoings with the application. It's worth noting that the caseworker guidance has really helpful content on fee waivers, including that there's no expectation that a third party should pay the fee or that anyone should get a loan. And there's also content on how the Home Office might apply discretion in relation to the evidence for fee waivers. Applicants should provide supporting documents as far as possible to evidence the information that they have provided in the application form. So they will have to provide their passport. They will also might have to provide a tuberculosis medical certificate if the country that they're living in is on the Home Office list for TB testing. Now, if an applicant really cannot comply with this requirement, it's impossible for them to comply with the TB testing requirement, then they could try to rely on a power that the Home Office has to waive the requirement if the Home Office considers it reasonable to do so on the facts. Or, of course, also applicants will have to provide an account of the domestic abuse and the circumstances of their abandonment, as well as any other evidence of domestic abuse that they can obtain. After filling in the form and submitting it online, applicants need to attend an appointment at a visa application centre to provide what the Home Office calls their biometric information, so that's their fingerprints and facial image, as well as their passport. An application isn't complete until this step is done, so the Home Office wouldn't consider it until after the appointment had been successfully concluded. So applicants are expected to produce a valid passport with their application and present it at their appointment. We know that victims of transnational marriage abandonment have their identity documents taken from them commonly. And so one of the first issues to address even before making the immigration application might be to obtain a new passport. So that's one of the early issues to look at in these cases. If a woman can't get a new passport, then advisors should have a look at the rules and guidance which provide for some discretion to accept alternative evidence of identity and nationality. And also, if you have a case where a woman just cannot attend a biometric appointment because of exceptional circumstances, you should consider that there is a Home Office policy on reusing biometrics or excusing applicants from that requirement, and it's worth looking at that in those rare cases. Applications can be refused for a variety of reasons. If an applicant doesn't meet the eligibility requirements that we've looked at, their application will be refused. However, the immigration rules also have what we call general grounds for refusal, which apply to all immigration categories relating to suitability. And for the benefit of the immigration advisors in the room, the grounds for refusal that apply are now in Part 9 of the immigration rules. And they include things like any criminal convictions, involvement in sham marriage, deception, previous breaches of immigration law, unpaid debts to the NHS, or unpaid litigation debts to the Home Office. There are some grounds of refusal that are mandatory and like serious criminal convictions, and others that are discretionary, like unpaid NHS debt. The only exception that we know exists for this route is that applications will not automatically be refused because of previous overstaying, which of course is really important for the victims that we work with. Helpfully, the caseworker guidance makes clear that it's only new suitability issues that have arisen since the last visa was granted that will be considered as part of the process. It also tells caseworkers to consider the impact of the domestic abuse when assessing suitability. Now, a word on dependent children. So dependent children can apply for settlement under the transnational marriage abandonment route at the same time as their parent and need to complete a totally separate application form. They can't qualify in their own right if the parent hasn't applied, so they have to apply either with or after the parent. Children can be eligible under this route if they were born in the UK, or if they previously had a visa as a dependent child, or if they were born outside the UK after their parents' partner visa had been granted. The child can't be living an independent life, so they must be living with their parent and not have a partner of their own. The most problematic element of the route is a requirement that children be supported and accommodated without relying on UK public funds. Now, public funds is a defined term and includes welfare benefits and council housing assistance. Caseworker guidance is essentially silent on what this means. We know that the parent herself, the woman, when she makes her application, doesn't have this requirement. So it's fine for her to rely on public funds on her return to the UK. It won't affect her application. However, if she declares that that's how she's going to support herself on return to the UK, it could well lead to a refusal of the child's application. This is a totally absurd policy and one that we are naturally resisting, and we will be if it leads to children's applications being refused. We will want to hear from you about your experiences of children applying from overseas. Adult dependent children who are 18 years and over can be eligible in limited circumstances. So over 18s can only qualify if they previously had a visa as a dependent child, and then they have extra requirements to meet. So they have an English language requirement, to meet, which generally will mean for many passing an English language test. And they have to pass a life in the UK test as well, which right now isn't actually possible to do from overseas. So one would expect that to be good enough reason for the Home Office to exercise discretion at the moment. I can see there have been some questions about how to get legal advice and support. Now, as we know, those applications for indefinite leave that are made inside the UK, we know they're in scope of legal aid. So legal aid is available for them. Applications from outside the UK are not yet automatically in scope of legal aid. And I say yet because we understand the government, the Ministry of Justice, plans to change legal aid laws so that applications will become automatically in scope of legal aid where they're made from overseas. But until that happens, there's just an additional administrative step in that the legal aid lawyer will have to apply for legal aid called exceptional case funding, which we expect to be granted for these overseas applications. We all know how difficult it is to get a legal aid advisor in the first place, and so it's likely to be necessary to think about charities with alternative funding, for example, law centres. We at Rights of Women have legal advice services, and we operate telephone advice lines where women and professionals supporting them can access immigration advice from a specialist immigration solicitor who has experience in transnational marriage abandonment. And we have 2 advice lines, and the details of them are on the slide there. Our immigration advice line, which is for women and professionals, as well as our professionals only advice line. And you can find all the opening hours and telephone numbers on our slide. At Rights of Women, we don't do legal aid work, but we do occasionally take on cases for full representation where we have capacity to do so. So we have transnational marriage abandonment cases at the moment. We don't generally take referrals for the casework service, and we tend to identify suitable cases through our advice line. So that is the way to contact us. We also have an online network for VORG and migration professionals, which can be a source of practical advice and guidance in cases, and you're welcome to request to join via our website. A final note on an issue relating to benefits and housing, which I have to say falls outside of the scope of immigration law and therefore outside of the scope of my expertise. But just to mention, for many benefits and housing assistance, the eligibility test includes whether someone has been habitually resident in the UK. Now, this isn't about immigration status. This is about living here. Are they living in the UK? Now, this could mean that a victim of transnational marriage abandonment who arrives in the UK with indefinite leave after an absence of many months or even years could be refused benefits or housing assistance where these tests apply. So, for example, that could mean that the DWP doesn't grant universal credit until they've been back in the UK for a few weeks or months. We are obviously pushing for exemptions in benefits and housing regulations so that these barriers to entitlement on return to the UK are completely removed, and we'll keep working on that. So that is the end of my presentation today about the new immigration rules for victims of abandonment to re-enter the UK. I'm going to hand over now to our final speaker, Pragna Patel again, who is going to talk more practically now about supporting abandoned women.
Thank you, Nicole. If I can just ask Anita for assistance with the slides again. Or Nicole, any one of you?
I'll do that for you.
Okay, thank you.
Bear with me.
I think it's slide 16, Nicole.
Yeah, there you go.
Thank you. So in the last 15 minutes or so, I just want to run through some tips and guidance on how to support women, abandoned women. Obviously, you know, this is all new for us. So we really need to see how it's all going to fit together and work, and we'll be monitoring very carefully the kind of hiccups and difficulties that people encounter trying to support women. But what I do want to say is, until the immigration rule change, many organizations who were contacted by women or contacted by someone on behalf of the abandoned women were told that there was little or nothing that could be done if they were abroad and if their visas had expired. But this is no longer the case, obviously, now with the change in the rules. However, the help needed for these women will have to be holistic and comprehensive, touching on meeting many needs that the victims, survivors have at the same time. And so what I really want to stress is that it will be necessary, if possible, to try and support women, refer women to specialist women's organizations to get the holistic and comprehensive support that will be needed to navigate their way through the systems and to ensure that all their needs are met on in returning and on return, to ensure that they make successful applications to begin with. So the first thing is to inform the victim or the survivor of the right to apply to the UK to return under the new victim of domestic abuse route that everybody has talked about and Nicole has highlighted, and to support the women in making an application to return if eligible. And as Nicole showed, it's an online application form. The first thing to do would obviously be to check what visa she had and to look at the eligibility requirements and the suitability requirements from her, and to assess what documents were taken away from her, the victim, and what documents she has herself, because she will need help in understanding what documents she will need, if she needs a new passport, and of course, and also, if possible, need to know what visa she, her last visa, the last visa that she had when she entered the UK previously. The key thing is also to take a detailed statement to support her application. And most women will not be able to fill this application on their own and will require assistance. And that is where those in the vulg sector, in particularly, if they haven't managed to make direct contact with a lawyer, should help women to make these applications and to support them in making the applications. So even before women begin to fill in the online application, it is really useful if a caseworker or an advocate can ensure that some of the details are taken that will help in filling the application. So the first thing that it will be useful to know is the history of immigration to the UK. What previous grant of leave did she have? And of course, that's relevant as to whether or not she can apply under the new route, and whether or not it has expired, not that expiry itself necessarily means she can't apply. But it's useful to have that information to begin with, or to get as much of that information as possible. The second thing is to take down the detailed history of abuse and abandonment that the person has faced. So not just in the UK, but also abroad, and also to take down a history of how she came to be abandoned. So it's useful to go through that history of abuse. What happened when she came to the UK, and how did she come to be abandoned? And then moving on to the next bit, the current situation. What is the current situation? Sorry, not the next slide. What is the current situation that she faces, both housing wise and financial? And this is relevant, of course, because if she's destitute while abroad, she doesn't have family support, or the family are unwilling to support, she has no relatives who can support her, she's not in work, she's more likely to be poor and vulnerable, then she will need to be assisted to apply for a fee waiver. And that's why taking down also the current situation that she's in is really, really important. And that evidence will also help. The evidence required to get that fee waiver, as when you do in the UK, is to seek supporting letters from family, friends, agencies who are providing support to her. And obviously, it's unlikely that she will have any kind of social services abroad that's supporting her. So really, we're looking at family and friends, or some charitable institution that may be providing support to her, however limited. And it's really important to note that and to get evidence of that. And if there is no evidence of her financial and housing situation, then need to explain why. And it may be that she is desperate, and that the family that she's living with, or the agent or the relatives that she's living with, don't want to get involved, or don't want to provide that kind of support, or are hostile. So but that needs to be explained, that that's the situation, and that's why there's no evidence. And still, she would need to try and get that fee waiver. And as Nicole has shown, that there is discretion there. So as much information as can be given about her financial and destitution is really, really important. And the details of the current circumstances should also look at current risks. Is she at risk of violence and abuse in the country of origin? Is the perpetrator's family there, or is he still making threats to her there? So all the kind of risk assessments you would consider for a woman if she was in the UK, it's still really vital to do that risk assessment abroad. It may be that the perpetrator's abandoned her and there's no contact and there's no risk as such, but if there is, it's really important because it forms part of the history of abuse and abandonment that needs to be set out. And along with that, the kind of cultural, economic, and emotional impact on her, including any health problems, trauma, post-traumatic stress disorder, depression, etc. These are also really important because they also go to the question of lack of support. They may go to the question of delays in applying. They may go to the question of destitution and isolation and so on. So setting out, you know, what's it like, the kind of barriers that Anita talked about, you know, the stigma, the shame, what's it, you know, living in a hostile environment, what does that do? What's the impact of that? These are all really critical questions that also go to evidence of abandonment. So these, being able to take this kind of statement or this history is really, really crucial. And it may be, because it's so difficult to have other evidence of abuse, it may be the only evidence that there is. And that's why it's so important to have a detailed statement from survivor victims, because that may be the only evidence. There may be nothing else. And her statement alone might make all the difference in terms of whether she can get the entry clearance. If there have been any reasons for delay, and you know, in this seminar we've talked a lot about why there might be delays in the woman seeking help to return. She may not know that there is a route. She may not know how to get to the right organizations for support. She may not have the money to get to the embassy or the, you know, or the consulate in her country of origin. There may be real reasons for delay. She may have tried to reconcile. The family may have tried to negotiate, thinking that that's a better way of dealing with the stigma, the shame, her destitution, and so on. For all these reasons, there may be real delays, but it's really important to set out the reasons for why she delayed, if it's more than a few months, in seeking help to return to the UK. And also it's worth knowing if there are any proceedings already begun in the UK, for example, divorce proceedings or proceedings involving children that have been initiated by the perpetrator or perhaps by the victim survivor herself. This is important because it might help to expedite decisions in terms of return to the UK so that she can engage in these proceedings properly. Those proceedings could also include criminal proceedings if, for example, she did manage to make a report to the police here, ongoing investigation, but then she was abandoned. So it's, you know, that's part of the taking of the statement in terms of the history of abandonment and the circumstances. And of course, having taken all this information, always seek advice and guidance from immigration lawyers, because once you've taken that information and helped to facilitate the survivor's access to a specialist immigration lawyer or law practitioner, they will be able to sort of guide you in terms of what other information may be needed and where there may be gaps and how to make that application. And obviously also seek support from family law practitioners and advice from them if children or family proceedings are underway, to ensure that all appropriate information is obtained and to ensure that the immigration lawyers, the family practitioners, law practitioners, you're all working in sync in terms of the information that's needed and you know, and to set down in the application form. And of course, the other thing that the women will be very concerned about is what happens to them when they return to the UK. And again, this is where the vulnerable sector organizations play an important role, because it is really important for women to know that once they're in the UK, particularly because most of them will be very isolated, they will need to know where they can go for ongoing support, help with resettlement, help with dealing with all the other needs that will be have to be met, including application for welfare benefits, accommodation, and so on. So next slide, please, Nicole. Okay, so part of the also, apart from gathering all the kind of, gathering the statement and history of abuse and abandonment and the current circumstances, it's also really important to help the victim survivor get the evidence that they need, either from the UK or abroad. And it's in exactly the same way as we would do in the UK, supporting women who are fleeing domestic abuse and need to gather their evidence for DVILR purposes. So, of course, as I said earlier, detailed statements from the survivors themselves is critical, and it may be the only evidence. And that's why, you know, when Nicole said that they will look at that if that's the only evidence, as long as it's reasonable, it's consistent, and it's credible. And so it's really important that those detailed statements are taken. There is nothing worse than jeopardizing women's applications because not enough detail was given in the first place. So it's better to try and front load and put as much information, appropriate information, as possible in the first instance. And of course, if they need to know if there are any reports that were made to police, social services, health visitors, any other agencies in the UK, if they had the chance at all to make those kinds of reports, or if they're being made abroad, if they've been, you know, reported their abuse to any agency abroad. And if they have, it's important to ascertain who they were made to and to try and get some kind of supporting letter from those agencies. Note that the guidance says they will give the same weight to evidence that's acquired from abroad as they would to evidence acquired in this country. So that's really important. So, you know, have they gone to a doctor? Have they sought help from a women's organization abroad or anyone else, a lawyer or anyone? Can we get support letters from those professionals or people or organizations? And of course, if family and friends and relatives who may have witnessed the abandonment, who witness the kind of circumstances in which the survivor finds herself, that's really important. And so it's important to get those kinds of statements. You know, the person who might have initially helped her in abroad, etc. Any medical evidence, does she report it to a health visitor, a midwife, GP in the UK? Has she reported it abroad? All that evidence is useful. And of course, also, again, it's useful to undertake a risk assessment of what happens to her if she returns, and also what situation is there. And that goes to, again, to the credibility of her as a victim of domestic abuse. So it's really important to plan ahead also, to line up access to and liaise with immigration, family, and other legal practitioners, so that when the victim survivor does arrive in the UK, she has immediate access and advice and can progress what needs to be progressed if it's in relation to family or other proceedings. And that's really, really important. So it's really useful to not only get the information, help gather the evidence, but also ensure that you can facilitate access to the appropriate professionals so that that is not delayed upon arrival. And then, of course, assist in the planning of the return to the UK. Of course, the application has to go in, the appointment has to be made for biometric, etc., as Nicole has explained. Make sure she has all the relevant documents to travel, new passport, the biometric situation, etc., all in order. And also discuss with her where she might stay in the UK. Does she have an acquaintance, friend, family that can support her? That's really important because she should be entitled to welfare benefits as soon as she gets her DVILR. It just might take a bit of time. And it's really important for her to know that even if she's staying with family and relatives, and for them to know too, that it's only temporarily, because she will be entitled to benefits and then can, you know, find her own feet in terms of housing and financial support. In the meantime, it's useful to have in place for when she returns emergency housing if there is no other relative or family or acquaintance that can help her, a refuge accommodation, B&B, whatever, and also what other financial support she might need pending successful applications for welfare benefits and so on. So I'll come back to that in a minute. Also, has she got a phone, access to a phone when she returns, so that if you need to stay in touch, how you will stay in touch, all of those kinds of practical details of how to assist in the planning of the return to the UK, and then, you know, maintaining contact after she returns to the UK is critical. And then the next slide. Okay, the other things to consider is collection at the airport. If she has no one here, no one to support or help her, can an advocate or a support worker collect her at the airport? Make sure, if you've never met her or if you've not seen her face and only dealt with it through phone or emails, you know what she looks like. You have a copy of her passport to recognize her. But collection at the airport is really important. Many women are lost, don't know what to do, very vulnerable, in a very vulnerable state. And like you would collect someone who needed to go to a refuge, it's part of the advocate's work, I would say. Housing options, again, emergency housing has been planned for and sorted. Note that in the short term, you can get some kind of financial support from Women's Aid. And I saw in the question and answer session, somebody set out in detail the kind of support that Women's Aid can provide through its flexible fund for victims of abuse. There's a one-off fund of £500, and there's a long-term fund of £2,500 to secure accommodation, to secure integration and resettlement as victims of domestic abuse. And certainly these women should qualify for that. And of course, there is the Migrant Victim Support Scheme led by SBS and other organizations that also provide short-term support of up to 3 months in relation to housing and financial subsistence costs. So, and there may be your own charities who've got a bit of emergency pots of money. It may be that the local council might be able to provide. Certainly Section 17 of the Children Act, if there are children involved, might also help. And you will find that although social services often present huge barriers even to obtaining Section 17 support, if they know that this person will be entitled to welfare benefits, it's just there's a delay in getting it, they may be more inclined to support her temporarily. And of course, she may want to continue with criminal proceedings, and so supporting her access police and to liaise with the police throughout the process of the criminal proceedings, if they're contemplated, is really key. And of course, finally, help with or referral to other appropriate agencies. Counselling may be an important part of the needs that must be met. If there are children involved, you know, support with navigating the education system, settling the children in school, other financial advice and so on. These are really important ways in which the Vogue sector provides holistic, wraparound, comprehensive support. And this is what's needed to not only ensure that hopefully women can make successful applications, but can also, you know, smooth their return to this country and help them sort of rebuild their lives and stand on their feet quickly. I'll stop there, and I think we'll probably get into question and answers, and I'm happy to take questions then as well.